We have learned from section 141 as to which assembly is an unlawful assembly. From section 142, we will learn as to who is a member of an unlawful assembly. The first thing to be noted here is that every person who is present in an unlawful assembly is not necessarily its member. So, who is a member? For being a member of an unlawful assembly, two things are required. Firstly, this person who is present in the assembly must have intentionally joined this unlawful assembly. If he is present there by chance, then he is not a member. For being a member, he must have intentionally joined the assembly. And the second, more important requirement is that this person must be aware of the facts which render the assembly unlawful. Now, which are those facts which render an assembly unlawful? From section 141, we know that for rendering an assembly unlawful, two facts must be present. The first fact is that the assembly comprises of 5 or more persons. The second requirement is that there must be a common object of the assembly, and that common object must be one or the other of the 5 objects which are specified in section 141. So, for being a member, the person who is present in the assembly should be aware of these two facts. He should be aware that this assembly comprises of 5 or more persons. He should also be aware that this assembly has a common object, and he should know which is that common object, and that common object must be one of those 5 objects which are specified in 141. Now, he need not know that the assembly is actually unlawful. For that matter, he might even consider that the assembly which he has joined is perfectly lawful. As far as he is concerned, in his understanding, the assembly may be perfectly lawful. So, it is not required that he himself should consider the assembly as unlawful. But the requirement is that he should be aware of the facts which render the assembly unlawful. And I'll repeat, the two facts which he should know is that the assembly comprises of 5 or more persons, and secondly, the assembly has a common object, and he should know what that common object is. He need not know that this common object is the one which is specified in section 141. He need not know anything about section 141, but he should know that there is a common object, and that common object should be known to him. What is that common object? And as a matter of fact, that common object should be the same which is specified in section 141. Then only that assembly will become unlawful. So, I'll repeat, every person who is present in the assembly is not necessarily a member of it. If a person is present there by chance, if he has not joined the assembly intentionally, if he has been brought there by force, if he has been brought there by deception, he is not a member. If he is not aware how many members are there in the assembly, then also he is not a member. If he is not aware about the common object of the assembly, then also he is not a member. Being a member of an unlawful assembly is punishable. Who is to be punished? Not every person who is present in the assembly. Punishment can be given only to a person who is a member of the unlawful assembly, and that's what section 143 says. Whoever is a member of an unlawful assembly shall be punished with imprisonment up to 6 months or fine or both. So only a member can be punished, and that is why it is all the more necessary to know who is a member and who is not a member. The punishment here is up to 6 months only. It's a small punishment as such, but yet the offense is cognizable, which means the police can arrest a member of the unlawful assembly without a warrant from a magistrate. The police cannot arrest every person who is present there. he must be a member. Only a member can be arrested because only a member has committed an offense. Every person who is present in the assembly unknowingly, unintentionally, unwittingly, he cannot be arrested because he is actually present but he is not a member. This distinction is vital, very important, should always be kept in mind. Then comes section 144, which increases this punishment from 6 months to 2 years for that member who is armed with a deadly weapon, or though he does not have a deadly weapon, but he has something which, if used as a weapon of offense, can cause death. Such a person, being a member of an unlawful assembly, shall be punishable with imprisonment of up to 2 years. This is an individual liability. Only that member will be punished with this higher punishment who is armed with such weapon. Other members who are not so armed will be punishable only up to 6 months. Section 145 says, whoever joins or continues in an unlawful assembly, knowing that such unlawful assembly has been commanded in a lawful manner to disperse, shall be punished with imprisonment up to 2 years. Here also, the punishment has been increased from 6 months to 2 years for that member who joins or continues in an unlawful assembly with the knowledge that this unlawful assembly has been commanded in a lawful manner to disperse. Which authority can command an unlawful assembly to disperse? The answer is not available in the Indian Penal Code. The answer is available in the Criminal Procedure Code. The provision is contained in section 129 of the CRPC, and that section authorizes an executive magistrate or officer in charge of a police station to command an unlawful assembly, to disperse. And once an unlawful assembly has been commanded to disperse, then it becomes the duty of the members of such assembly to disperse accordingly. It's the duty of the members of the assembly, and we know who are members and who are not members. It's a legal duty. The member is bound to disperse once he has been commanded. What happens if he does not disperse? He commits an offense. He can be forcibly made to disperse, that is one thing, that is from CRPC, which says that if upon being so commanded, any such assembly does not disperse, then the executive magistrate or the police officer may proceed to disperse such assembly by force, if necessary by arresting its members. So that is one thing. And the second thing is that if a member of the unlawful assembly does not disperse despite being commanded by a lawful authority, then he becomes punishable under section 145 with an imprisonment of up to 2 years. Then a new offense of writing is described in section 146. Wherever force or violence is used by an unlawful assembly or by any member thereof, even if nothing is done by members of an unlawful assembly, the mere fact that he has joined an unlawful assembly, the member is punishable by that mere fact. But now, the offense becomes aggravated. If force or violence is used by the unlawful assembly or by any member of the assembly in prosecution of the common object of such assembly, we have already seen that every unlawful assembly must have a common object, and that common object must be one of the 5 which has been described in section 141. So if force or violence is used in prosecution of the common object, then every member of such assembly is guilty of the offense of writing. A new offense of writing has been described here. And who is guilty? Every member. Now, the force might have been used only by one member. violence might have been used only by one member. Even then, every member becomes guilty of this new offense. This section incorporates the principle of vicarious liability. A person who has not used violence, a person who has not used force, will be liable for use of force or violence by another person. If any member of the assembly has used force or violence, then every other member will also suffer and he will be liable to a higher punishment. He will be liable to a distinct offense, that offense of writing. So here, even though other member has not done anything, he becomes liable to punishment for an act done by another member. Punishment for the offense of writing is imprisonment up to 2 years. It should be borne in mind that this is a distinct offense. Being a member of unlawful assembly is punishable under section 143 with an imprisonment of up to 6 months. But being guilty of writing is punishable under section 147 with a higher punishment, higher imprisonment of up to 2 years. 143 is one offense, 147 is a distinct offense. Whoever is guilty of writing being armed with a deadly weapon or similar thing shall be punished with a higher punishment of imprisonment up to 3 years. Now this is individual punishment. Not every member will be punished with this higher imprisonment. Only that member who is armed with a deadly weapon. So under 147, every member becomes liable for punishment. But here only that member is liable to a higher punishment who is armed with a deadly weapon. Other members who are guilty of writing will be punished only with the imprisonment up to 2 years.